Supreme Court of India v. Senthil Balaji vs. Deputy Director, Directorate of Enforcement decided on September 26, 2024 SCC Online SC 2626 Facts of the case. Between 2011 and 2016, the appellant was Transport Minister in the government of Tamil Nadu while discharging his duties as a minister. In connivance with his personal assistant and his brother, he collected large amounts by promising job opportunities to several persons in various positions in the Transport Department. This led to the registering of 3 FIR under sections 120B/34, 419, 420, 467 and 471 of the Penal Code 1860 and section 7, 12, 13, 2, read with section 13, 1d of the Prevention of Corruption Act 1988. These offenses are scheduled offenses within the meaning of Section 2(y) of the PML against the appellant and others. The appellant was arrested on June 14, 2023 in connection with the said ECIR and was remanded to judicial custody. A complaint was filed for the offense under Section 3 of the PMLA Act, bail application preferred by the appellant under Section 439 of CRPC rejected by the High Court. Findings of the court. As of now, the appellant has been incarcerated for more than 15 months in connection with the offense punishable under Section 4 of the PMLA. The minimum punishment for an offense punishable under Section 4 is imprisonment for 3 years, which may extend to 7 years. If the scheduled offenses are under paragraph 2 of Part A of the schedule in the PMLA, the sentence may extend to 10 years. In the appellant's case, the maximum sentence can be of 7 years as there is no scheduled offense under paragraph 2 of Part A of Schedule 2 alleged against the appellant. In the facts of the case, there is no possibility of the trial of the scheduled offenses commencing in the near future. Therefore, we see no possibility of both trials concluding within a few years. Considering the gravity of the offenses in such statutes, expeditious disposal of trials for the crimes under these statutes is contemplated. Moreover, such statutes contain provisions laying down higher threshold for the grant of bail. It is a well-settled principle of our criminal jurisprudence that bail is the rule, and jail is the exception. These stringent provisions regarding the grant of bail, such as Section 45(1)(3) of the PMLA, cannot become a tool which can be used to incarcerate the accused without trial for an unreasonably long time. As stated earlier, the appellant has been incarcerated for 15 months or more for the offense punishable under the PMLA. In the facts of the case, the trial of the scheduled offenses and, consequently, the PMLA offense is not likely to be completed in 3 to 4 years or even more. If the appellant's detention is continued, it will amount to an infringement of his fundamental right under Article 21 of the Constitution of India of speedy trial. The appeal is allowed, and the appellant shall be enlarged on bail till the final on the following conditions. A. The appellant shall furnish bail bonds in the sum of Rs 25 lakh with 2 sureties in the like amount. B. The appellant shall not directly or indirectly attempt to contact or communicate with the prosecution witnesses and victims of the 3 scheduled offenses in any manner. If it is found that the appellant directly or indirectly made even an attempt to contact any prosecution witness or victim in the scheduled as well as offenses under the PMLA, it will be a ground to cancel the bail granted to the appellant. C. The appellant shall mark his attendance every Monday and Friday between 11 a.m. and 12 noon in the office of the Deputy Director, the Directorate of Enforcement at Chennai. He shall also appear on the first Saturday of every calendar month before the investigating officers of the 3 scheduled offenses. D. Before the appellant is enlarged on bail, he shall surrender his passport to the special court under the PMLA at Chennai. E. The appellant shall regularly and punctually remain present before the courts dealing with scheduled offenses as well as the special court and shall cooperate with the courts for early disposal of cases. And F. If the appellant seeks adjournments on non-existing or frivolous grounds or creates hurdles in the early disposal of the cases mentioned above, the bail granted to him shall be liable to be cancelled. The appeal is allowed on the above terms.